like two topics, Industrial Dispute Act and Employment Standing Order Act. So these were the two topics. So related to that, there is a small slide which I would be showing to all of you, and my discussion will move on accordingly. Fine. Uh, Right. So if I talk about industrial dispute is a very common topic. It's a very common thing which we come across every time, not even in an industrial setup, but also in the factory setup, in any organization. Okay. And something which is a matter of and they are different organization or by the management to avoid these disputes, because we all know that the disputes lead to numbers of issues, and the operation or the performance of the company get hampered, right? So but if we go by the definition of Industrial Dispute Act 1947, industrial disputes are what I've written in the slides are organized protest against existing terms of employment or conditions of work. So according to Industrial Dispute Act 1947, the industrial dispute means any dispute or differences between the employer and the employer, between the employer and workmen, or between the workman and workmen. So it is not. So you can't say that the disputes will always happen between the management and the workers, or between the workers and workers. It may happen between the employers and employers also. So any party whosoever is involved in the organizational setup and they are working together, they may get involved into this kind of disputes, right? So it will actually going to hamper the conditions of your mental peace will also get hampered, and in a way the performance of the organization will also get hampered. So many a time it has been seen that the disputes occur because of the issues related to employment, right? So if you're not happy with what the management are saying to you, or you want something else, or your satisfaction level are not reached, so in that case we always come up with the issue, and we have some strife. So you can see the strife between the employers and the employees. So in industrial disputes, not only the personal dispute of a person are covered, but it can also occur because of the issues raised among the workers community having common interest. So okay, so it may not be possible that only a personal issues, if not properly addressed, you will come up with the disputes. It may be that if something is not satisfied, if something is not happening as per the norms, okay, the management is not following the norms which the management has already spoke to you, or which the management has already conveyed to you. So in that case also the industrial disputes occur. Now the question arises that how to get the prevention out of this industrial dispute. See, the consequences of industrial disputes will definitely going to be very harmful, not only to the honor of the industry's workers, but the impact is going to come to the effects of this industrial dispute will also be to the economy as well, nation as well, and it will finally results to the loss of productivity, profit, market share, and even the situation can be that the industrial dispute need to be addressed very properly. The prevention of industrial dispute has to be taken in a very proactive manner. Proactive approach has to be there, where the organization can undertake various actions through which the occurrence of these industrial disputes can be prevented. Okay, we all know this old saying like prevention is better than cure. So management always take numbers of steps in order to control these kind of industrial disputes. So I've written few points in the slide. As you can see, I will discuss one by one what they are and what they include. So first point I've written is model standing orders, right? So model standing orders means the rules, the terms and the conditions of employment which are actually being conveyed to the person, and that these standing orders are actually uniform for everyone, right? In that standing orders, you will find that the specific duties, responsibilities of both the employers and the employees are well written. So as an employee, you will also come to know what responsibilities you have to take up, what duties you will be having. And apart from that, it is also a document which will cover the responsibilities and duties of the employer as well. So by model of standing orders, actually the behavior or the acts of the person are actually regulated. Okay, so these standing orders are actually, you can say that these are very basic, or you can say the basis for maintaining a very harmonious relationship between the employers and employees. So any industrial disputes, any factory which is employing more than 100 workers is required to frame a standing orders in consultation with the workers. So obviously, whatever rules and regulations you are writing, that has to be understood by by the worker itself. The worker should agree to that, right? So many a time, what happens that when you join the organization, you will be conveyed about the rules and regulations, the timing, the codes, the disciplines, and various things, right? So these order must be certified and displayed properly to the employer, to the workers whosoever is joining. So information of the standing orders has to be very much clear, right? The next part is code of industrial dispute. If I have to discuss about the code of industrial dispute, it simply means it is a document which will define the rules and responsibilities of the employers and the workers. So, what will be the objective of this code of industrial dispute? Discipline. The objective of this industrial dispute, I'm so sorry, of industrial discipline is to secure, is to,
Discipline.
is to, is to look into the aspect that further there is if some disputes will happen, then there should be some bodies which will take care.
Discipline.
I mean to say that negotiation, conciliation, and voluntary arbitration to eliminate all forms of violences. Okay, so the code of industrial discipline will actually talk about as how to maintain the discipline in the industrial setup, as how to avoid any kind of work stoppage, or to provide a constructive or a cooperative framework under which the concerned parties will work, right? So code of industrial discipline will look after the all the discipline aspect which will actually applies to the workers and the employers who are working in the industrial setup. Now, if you go by the third point, works committee, work committee, mm, the Industrial Dispute 1947 has provided for the establishment of work committees. So, in case of any industrial establishment in which 100 or more workers are employed, a work committee is constituted, right? So, the workers is to be so. Uh, See, it shall be the duty of the work committee to promote the measures for securing and preserving the good relationship among the employees and the workers. So, work committee will also look into those aspects where the proper relationships should be maintained between the employees and the workers. Now, similarly, there are joint management councils, suggestion schemes, joint councils. These are also the other bodies, and the purpose is not very much different, but it is very much similar to what I have spoken to you. It is the purpose is the purpose mainly is to settle the disputes by negotiation, by any kind of agreement, right? By maintaining the discipline in the organization, and to avoid the workers if they are going for any kind of stoppage in the work, or if they are going to form any kind of agitation in the industrial setup. So that has to be taken care by these councils, schemes, and committees. Now the next point which is written is collective bargaining. I would like to discuss on this. Collective bargaining is nothing, right? It's a process. Collective bargaining is a process. We actually practice this thing in our day-to-day life also. Collective bargaining is a process in which what will happen, there's a representative, okay, representative from the of the employers also
Wow.
and the employees also. So what they will do, they will meet together, they will attempt to negotiate a contract governing the relationship. So collective bargaining actually involves a kind of a discussion, or it's a kind of a negotiation which has to be done between the two groups, so as to so that the terms and the conditions of employment which they have agreed will be taken care of. Okay, so the terms and the conditions of employment which they have agreed at the time of joining the industry, that has to be properly uh, properly run. Now, the next thing which is written is labor welfare officers. See, the Factories Act 1948 actually provides for the appointment of labor welfare officers. In every factory which is employing 500 or more workers, the officers look after the facilities that the factory must be provided with proper health safety measures, health measures, safety measures, welfare of the workers. So it is the duty of the officers to look after that all the facilities in the factory must be provided. Okay, so it means that if there is a communication, see, sometimes what happens that the facility is already there, right? The welfare facilities are there, but due to lack of awareness or due to lack of communication between the two parties, it may happen that there is going to be industrial dispute between them, right? They will not be happy with the administration. So it is very much important that the labor welfare officer must explain that what are the different provisions which are there, what are the various schemes and healthy for a healthy performance in the workplace, what are the different schemes which the organization has thought of and what they are implementing. So industrial relation through proper administration of standing orders and grievance procedure is very much important. In any organization where the grievance procedure is totally not followed, in that case, obviously, the employees will not be happy, right? So once you are addressing your problem to the management, it has to be addressed properly. The next point which I've written is tripartite bodies. So these are those bodies which have constituted not only at the state level, but also at the central and the nation level. Now, Indian Labour Conference, standing labour committees, wage boards, and industrial committees actually operate at the central level. When we talk about the state level, the state labour advisory boards are there, which are set up at the state level. So all these bodies actually play a very important role in reaching an agreement on which the labor related issues will be addressed. So recommendations which are given by these bodies are, however, a kind of an advisory in nature and not statutory. So I will not say that the whatever these tripartite bodies they are going to be very much like nailed. Okay, these bodies actually they give their recommendations and in a form of advice. You can follow it, you cannot follow it, but it is up to the agreed party whether they agree on that or they won't agree. Now, if you go by the machinery for the settlements of industrial disputes, as I've written 3 points: conciliation, arbitration, and adjudication. So, what conciliation is? See, conciliation refers to the process by which the representative of the employees and the employers are brought together. Why? They are brought together because they are having some issues, and there is a need that they must take these issues in front of the third party with a purpose of discussion, right? So a discussion will be there, a kind of a reconcile will be there, and if there is a difference of opinion is there between the two parties, the objective is that they must agree on a common point, a common mutual consent has to be established between these parties. Okay, so the third party actually act as a facilitator in this process. So you can say that conciliation is a type of a state intervention in settling the industrial dispute. Industrial Dispute Act actually empowers the central and the state government to appoint the conciliation officers and the board of conciliation. But it depends upon, here I want to say that as and when the situation demands, right? So conciliation officers are actually appointed, are so conciliation officers are the appropriate government. See, by the notification of official gazette, they appoint such members of a person as it think whether it think it is fit, or then they can do it, or if they don't think it is fit, then they leave it, right? So it depends upon the situation which demands. Now, the important thing is what are the different duties of this
कितना
conciliation
बस जा रहा
officers?
परिणाम देखो
First thing is
पूरा
to
एकदम
hold
वॉल्वो बस चल
conciliation
जाएगा
proceedings with the view to
बड़ा
arrive
बड़ा
an
बस
amicable settlement between the parties concerned. Next is to investigate the disputes in order to bring about the settlement between the parties. The third can be I can say that to send a report or to send a memorandum of settlement to the appropriate government. And the next can be like to report to the government stating the steps that can be taken by them. So the conciliation officers, however, has no power to force a settlement. They cannot force any kind of settlement, but you can say that he can only persuade and assist the parties to reach an agreement. So they can only provide an assistance, they can only provide
common
a
consensus
kind of a suggestion, right? The Industrial Dispute Act actually prohibits the strikes and lockouts during that time when the conciliation proceedings are in process. So obviously there can't be any kind of a lockout, or they can't the work cannot be stopped if the matter is under the conciliation proceedings. If the conciliation proceedings is in progress. Now, if I have to discuss about the arbitration, see, arbitration is nothing but it is a process in which the neutral third party listen to the disputing parties. If you and me, if we both are fighting, then there has to be a third person there must be a third person who should
arbitrate
listen to us. And they will, so the purpose is what? The purpose is, now the question arises, what is the actually functioning of this arbitration? To gather the information about the dispute, what has happened, whether you are saying correct or whether I am saying correct, and then to take a decision. And if you are approaching an arbitration process, then you have to understand that whatever the decision which is being taken by this arbitration under this arbitration process is going to be a binding on both of us, right? So the conciliator is simply in the previous one conciliation. So there the conciliator simply assist the parties to come to a settlement. But if you are talking about an arbitration process, here the arbitrator listen to both the parties and then they give their judgment, which you have to listen. Now, see, in conciliation can be a long process, right? When we are approaching, and then it is up to your choice. You can go by the decision, you cannot go by the decision. So simply, just like why we both will agree, right? If favor is coming to me, I will agree and you will not agree. And if favor is coming for your side, you will agree and I will have a problem. So in that case, there are certain advantages of arbitration process. Actually, we both need to have a good faith in the process, in the arbitration process. So arbitration process, the first advantage is that it is established by the parties themselves, that who is going to listen, who is going to be the neutral third party. And therefore, since we both have taken a decision that who is going to be the third party, then both the parties will have to have a good faith in the arbitration process. The process is I can say that the process is quite informal one, and it is quite a flexible in nature. Now it is, since it is based on the mutual consent of the parties, I think it will be a better way in order to build a healthy industrial relationship. Now there can be some demerits also of arbitration, like there can be some delay which may or which often occur in settlement of disputes. Arbitration can be an expensive process, right? And the expenses are to be shared by both the parties, by the labor and the management, if you talk about from the industrial point of view. The judgment can become arbitrary when the arbitrator is, see, if can be, here what happened that suppose we both have approached to the neutral party, and that neutral party has given a decision. Now, the judgment which that arbitrator has given, we both are having a doubt on that. So, actually, what is happening that without knowing the competency or without knowing the experience of the arbitrator, we both are approaching. So, in that case, if the arbitrator is incompetent, and if you feel that the decision taken by him is a biased one, then what will happen? We both will not going to, we will have a feeling that we have not got the justice, right? So Arbitration, if you will discuss in depth, arbitration is also, there are actually two types of arbitration. One is the voluntary arbitration, and the another one is compulsory. So voluntary arbitration, there what happens that the arbitrator is appointed by both the parties through mutual consent, and the arbitrator act only when the dispute is referred to him, right? But in compulsory arbitration, what happened? The parties are required to refer the dispute to the arbitrator, whether they like or not like, whether it is up to their wish or whether it is not up to their wish. So, as a compulsory arbitration means what? That whenever there is some other stronger reason, the appropriate government can force the party to refer to the dispute. If the government feel that there must be some decision which has to be taken in a concrete manner, then compulsory arbitration is going to apply, where the suggestions coming from that arbitration because of the dispute has to be uh, 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 understood, and it has to be taken up by both of us, right? So by the word it's very simple. Voluntary meant it is up to the wish, and compulsory means something which is happening and you have to, and your wish is not there. Now if you go by the third point, that is adjudication. Adjudication means the what should I say? Adjudication is the actually the ultimate, you can say it is the ultimate remedy for settlement of any dispute. Why I'm saying so? Because adjudication means there is an intervention of a legal authority, right? And that legal authority is appointed by the government, and the purpose is to make the settlement, okay? And the decision which is being taken by under this process is going to be binding on both of us. So in other way, in other explanation, I can say that adjudication simply means that it is a mandatory settlement, right? Something which is has to be understood and which has to be accepted by both of us. So if there is an industrial dispute by the labor court or by the tribunal, for the purpose of the adjudication, Industrial Dispute Act has actually formed, you might have heard about that, three tiers of machinery. So adjudication, for that purpose, the Industrial Dispute Act has got three tier of machinery. The first one was labor court. The another one was industrial tribunal, and then there was and the third one is national. Okay, yeah. So the first I told you about the labor court, industrial tribunal, and national tribunal. Now the question arises that what is labor court? Okay, so labor court is what? The appointment, the appropriate, actually the appropriate government, whosoever is there, through notification in the official gazette, they constitute one or more labor court. The purpose of this labor court is to settle the industrial dispute relating to any matters. It can be, right? It can be like matter related to if the workman is wrongfully dismissed, right? If the workers is not uh, has been discharged from his job without a genuine reason, if there is a problem that the worker uh, is not getting a relief or a grant, right? Or there can be uh, there can be strikes, or any kind of reason can be there, like if you are not getting any kind of privilege. So in that way you can approach the labor court. So whenever, so uh, somebody is approaching or referring to the labor court for adjudication, it shall hold its proceeding according to the norms, and there is going to be some period which is involved, right? So you have to first submit the report to the appropriate government that what has happened, what is the fact of that, and the labor court will look into the aspect. It will try to find for the adjudication as per the provisions of the law, and and accordingly you will get the justice. Now, if we talk about the industrial dispute, the appropriate government, then again by the notification of the official gazette, they constitute one or more industrial tribunal for adjudication of industrial disputes. Now, industrial disputes here, the scope is quite wide because it includes the matters like it can be wages related, it can be any kind of compensatory allowances that you are not getting, or it can be like hours of work, or if you are not happy with the rest intervals which you have been provided with, or it can be leave with if you are asking for a leave with wage, right, and holidays. It can also be related to any kind of profit sharing, employment provident fund, rules of discipline, or any kind of retrenchment that has happened, or if you are not happy with the working shift in a, as per the accordance, because I've already told you that standing orders are there which will actually explain your rights and duties and responsibilities. So if something is written there and you are if something is not written there and you are being forced to do that, you can definitely approach to the industrial dispute, industrial tribunal. So, in a nutshell, I can say here that industrial tribunal actually hold all their proceedings as per the reports which is submitted to them, right? And they will take their own time to reach to a solution. If you will go by the okay, if you'll go by the third thing which I've discussed with you, is that in national tribunal, right? So the central government, by the notification of official gazette, actually constitute the national tribunal. It is again for the adjudication of any kinds of industrial disputes that happen. So here the issues or the problems which are very big in nature. I mean to say that those problems are matter of national importance, matters which are of the nature that if something will not be taken care of, or then the interest of the nation or the citizen of the country is going to be hampered. So it is the duty of national tribunal to hold its proceeding very minutely, very carefully, submit its report to the central government within the stipulated time, so that the aggrieved party will get the justice, right? So national tribunal, industrial tribunal, and then labor court, they have got their own specifics. So these three tier machineries actually function in different manner. And the adjudication, by now you might have understood that it is a ultimate legal remedy where the person can approach for the settlement of any dispute act. Okay, so adjudication, simply what does it mean? It means that any kind of intervention which is very much legal, right? Legal authority which are there, appointed by the government to make the settlements. And these settlements or the decisions are going to be binding on both the parties. Okay. So again, I'll repeat that for this purpose of adjudication, the Industrial Disputes Act provides three tier which I discussed with you: labor court, national tribunal, and industrial tribunal. Okay. So first is labor court, industrial tribunal, and then national tribunal. Now I'll discuss with the next, my next topic for today. This is all about industrial dispute. Industrial dispute I have discussed with you. Now, as per the communication, I'm supposed to, Industrial Dispute Act 1947 is over. Now I'll start with the new topic, that is Industrial Employment Standing Order Act 1946. Right. So I had already discussed a little about this in my previous discussion, but I would like to give a gist and an overview of what this deals with. So standing order means that rules related to the matter set out in the schedule. Standing order means a rule of conduct of the workman employed in the industrial establishment. I'm reading out from the slide only. The object of the act is to require the employers in the industrial establishment to formally define the conditions of employment, right? So it's very difficult to make you understand by the bookish language. So I'll try to give my own explanation. So Industrial Employment Standing Order Act 1946 simply means that it is a rule book which is going to discuss, which will actually discuss the different aspects which is related to your employment, your job life, right? So first, the thing which it will discuss is classification of workers, whether you're permanent worker, labor, temporary, your probationary, or whatsoever. So it will first describe the classifications of workmen. Then it will also discuss the manner of intimating to workmen period and hours of work, how many holidays you are going to avail, how many pay days will be there. So it will also discuss about the shift of working, whether day or night, attendance, how your attendance is going to be recorded. If you are late, then how many lates are allowed in a week, conditions of the procedure, applying that how many grants, leaves or holidays that you are going to get. So all these things will be obviously included in this Employment Standing Order Act. A copy of it will be signed by you, and a signed copy will be retained by the management itself. Here, it also includes, it will actually discuss all the things like how you will going to enter the premises, which gate you are going to enter, the liability to different search, when will be the closing and the opening of, I've not written, when there will be closing and opening of of the industrial establishment, right? So so basically, I mean to say that this act will actually discuss about the rights, the not only the rights but also the liabilities of the employers and the workmen, which is arising out of the employment relationship which is there, right? So not only this, but as far as my knowledge is concerned, standing order actually also discuss about the terminations, like in what terms your job can be terminated, how many days of notice period you need to serve to the employer. Hmm. In If you're doing some misconduct, then what will be the way of suspension, how the misconduct will be handled, and what are the things which will come under the misconduct. And if you are facing some wrongful act is there in the organization, then how the management is going to support you, where you can redress your issues. If some unfair treatment is going to happen with you, then where you are going to take those matters. So everything is going to be discussed in that book. Okay. So, so this Industrial Employment Standing Act 1946 applies applies for whole of India. Okay, it applies for whole of India, applies to every industrial establishment wherein the 100 or more workmen are employed, and where the employed, uh, 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 where the employees are employed under the rules and the regulations of the industrial sector. So, provided that the appropriate government is there, after giving this kind of information to the employees, then the management will look into that whether you are taking care of all these things or not. If you are not abiding the Standing Orders Act 1961, then it may happen that the management can take an action. So there are different appellant authorities. These authorities actually will take care whether the rules and regulations which are being written in the standing orders are actually followed or not. So obviously, if you talk about the industrial setup, first of all, it is being explained whether what is industrial establishment means. Okay, so if you will go by different sections, like industrial establishment is defined in the clause 2 of section 2 of Payment Wages Act 1936 in different way. The factories as defined in clause section 2 of Factories Act 1948. So if you go by the industrial establishment definition, the railway is defining section 2 of Industrial Railway Act 1890. So there are different definitions of industrial disputes which are there. next thing which I've written is a submission of draft of standing orders. So what will happen that within the 6 months from the date on which this act becomes applicable to any industrial establishment, the employers shall submit to the certifying officer 5 copies of the draft standing orders proposed by him for the adoption in any industrial establishment. So the provisions shall be made in such a way that the draft for every matter set out in this schedule, which may be applicable to the industrial establishment also, wherein the model standing orders have to be prescribed, shall, okay. And so the draft of these standing orders must be submitted under this section. And the not only the workers, not only the employees, but the other person which are related, like the trade unions, they will also cover under this. They will also be covered under this, right? So conditions of certification of standing orders are also there, where the standing orders shall be certified under different acts. Okay, like if you are complaining against something, then it has to be covered under that industrial establishment. If something is happening to you outside the industrial premises, that will obviously not be covered under the standing orders, right? So it is very much important that that the certifying officers or the appellant or authorities to give the fairness or reasonableness to the provision of any standing orders. Whatever which is fair and what is reasonable, that must be included, or that is obviously there in the standing order. Now, just wait for a moment. Let's come to the there are penalties and procedures. See, any employer who fails to submit the draft of standing orders as per requirement by section 3, who modified his standing otherwise, then what will happen that it is a act which is to be punished. Okay, it is a punishable thing, and with a definite fine is there, and which has to be extended, which can be extended to the limit which is there, which can be extended to 5,000 rupees in case of a continuation of offense, with a further fine which may extend to more amount, right? So it depends upon the offenses that is being continued. So the employer has to look into the thing that the standing order acts are totally being properly planned, properly drafted, properly submitted, and is actually being followed. It is very much important that all the people must understand the standing order, and it is the duty of the HR manager itself that whenever some employees join the organization, they must be informed about the certain aspects which are to be covered by them. Some obviously on the very first day the employees make the employee understood about the standing orders, because if they will abide that, then what will happen, it is going to be not good for the company itself, because it spreads like a fire, right? If you're doing something wrong, the management is not going to accept that, and obviously it is going to be a punishable act. So obviously the standing orders act are very much important, because it deals with the various important issues like attendance, like late coming, shift, working shift of the employees. You must know whether as what time you have to reach to the companies. So if these things are not followed, is a very common thing, it is going to be the problematic situations for the company and for the person who is involved in this, right? So there are different interpretations which are given of this law. It depends. There are various certification of standing orders are there, which has to be understood. Now when the standing orders become concrete, it has to be applied to the industrial setup, proper duration, and on in different durations, you can modify the standing orders as well, Okay, so standing order finally, when it gets certified by some act, it is not that you cannot modify that. You can modify that, and the modified standing orders can also come into operations, subject that the modification is required as per the need. Just wait for a second. पानी दीजिएगा एक गिलास. बॉटल होगा मेरा वहीं पर, थोड़ा सा पानी गला में थोड़ा सा प्रॉब्लम. Hello. Maybe the voice is now okay. So I think my voice is audible to all, because this is just one-way communication. This side I'm not able to hear. So a standing order, in a nutshell, I would like to say it is an automated method of any organization that has to be followed, right? Why I'm saying so, because sometimes what happens that if the employees are not happy, they may go under different strikes and all that, and it may provide different legal complications as well. Because I've taught to, as I've told you, that there are going to be disputes and all that. So it is just a rule book which any establishment need to understand. This is all for today. What more I'll say? If you want me to answer something, you can write in the chat box. I can see and I can reply. Nothing is coming on the screen.
Hello. Hello. Hello.
See, I've already discussed with the. If you have something to ask on this, you can obviously come with your questions in the chat box.
Hello. Hello.
It is see, Standing Orders Act are very much important for an organization setup, which is actually handling with those activities which are hazardous to the employees, right? So, like the premises where the proper rules and regulations are not followed, that may cause damage to the employees, right? Because recently we have also heard about the Visakhapatnam case. So, in that case, what happened that the employees associated with the industrial setup, they must know what has to be followed, because any mishandling of any kind of machines or any kind of lacking in the knowledge of layout and the conditions of place of work may raise different kind of issues, right? So it is the duty of the manager must has to ensure that the rules are being properly followed. The importance is basically for those industrial setup where the chemicals are being manufactured, right? So those places, it is very much important that proper planning of the work process has to be informed. If there is some changes which is there in the workplace, that has to be, because that is the reason why I told you that it can be amended, right? So uh, informations can also be upgraded about the work process that is there. So the most efficient way to identify the potential risk and hazard is when the work activities are being properly designed, planned, and discussed. Okay, so a risk assessment is very much important in any kind of in any industrial setup, because if it is not there, then obviously the risk control is going to be very much difficult, right? So, and there comes the importance of standing orders. The employer eliminate how to eliminate. Sometimes it's not possible to eliminate every time, right? So in that case, you have to control that risk also. So the problem is that if the managers will not communicate properly the rules and regulations and as how to do and what not to do, the rule book, then it may cause some health hazard to the employees, and obviously it will lead to a legal issue for the company as well. So this is all for today, and I hope I have tried to make you understood about these things, because today I've discussed with industrial disputes. The topic was very wide, but then I've got a message. Just
Hello?
wait.
Hello? Hello? Hello?
Gautam sir, I have seen your message in my WhatsApp. You are writing,
Is
I
it
am you are not audible, sir. You are not audible. But then I can see you have written, okay, madam. So can I wind up? If you can text me,
ma-
you can
ma-
text me something. I will get to know.
it is not at all audible,
Please
ma'am.
text me something. I'm
Hello?
waiting for your
Hello?
message.
Is it audible? Hello?
Today I
Pallavi,
don't
ma'am.
know why this voice is not coming.
Madam, you are audible, I think.
But
Can
he
you
could,
hear me?
no, no, she could not able to hear us. That is what the issue.
Okay, okay.
So
Okay, okay.
please,
Then we should wind
I
up, sir, no?
Gautam sir, I think I am able. You are able to hear me because I'm waiting for. Okay, I've got a message from you. Okay, so I think
yeah,
I can wind up. The class
okay,
time is
okay,
also over.
okay, ma'am.
Uh,
Okay,
so I'm leaving the this meeting.
okay,
Fine, all of you. Good night, and I hope can only hope that I would have make you understood today. Okay, good night. Good night, Gautam sir, and good night, all the students. Thank you.
okay, okay, Ajit ji, Sana ji. Okay, good night.